Thank you all for joining. This is going to be hopefully a few tips. You take away a few different ideas or different things that you want to do as you start thinking about future for yourself or maybe for loved ones. Just a few little housekeeping things that I wanted to let everyone know. If you do have a question, which I encourage all questions, please click on the chat feature at the bottom and you can chat your question directly to Becky. She is my wonderful facilitator, moderator. She's here helping me make sure that we can get through all of this and I can get you all the information that you need. So like I said before, I'm Regan Carlo here at Metco Credit Union. Many of you I know, some of you I don't, but hopefully I will soon. Again, if you have any questions along, through the slides, please ask away. There is a section at the end. Hopefully we can get to some specific questions. Maybe there's things that I don't answer or answer, but you want a little bit more clarification on it. So by all means, please chat your questions directly to Becky. Okay. So this is a little bit about the agenda. I'm going to go through some terms, define them, and really kind of put it into terms that we all understand versus the real specific legal jargon. I also want to describe what to expect financially after a loved one passes, and then also describe the different options for accessing the loved one's funds. So this might be through their wishes, how you can help them after they've passed. And then we'll take a little bit of time at the end to go through some of those questions that you might have, or maybe something comes up along the way. Okay, so as we talk about those terms, I have them all listed here. These are the ones that we're going to touch on, hopefully kind of tell you what the difference is between one or the other. So first and foremost, joint owner is always something that comes up when we meet with members to talk about kind of the next steps. But a joint owner is two or more owners on the same account. Now they'll have the same responsibilities as one another. So this might be with a close family member, maybe a parent. A lot of times it's a spouse. I know like my husband and I have joint accounts as well. And then in terms of documents that are needed to become joint owners, there's not a specific legal document that's needed, but what you will actually do is sign what's called a signature form at the financial institution that you're wishing to have a joint owner placed on your account, or maybe you're wanting to be a joint owner on another account. Regardless of who's listed first, they have the same responsibilities. So if my husband's listed first on our joint account, but I'm second, I can do the same things that he can do. It's just a preference, or maybe as you start to talk about who's opening the accounts, maybe one person just comes first. Equal responsibility. Power of attorney. This is also known as POA, so maybe sometimes you've heard that. The definition of a power of attorney or letter of attorney is a written authorization, which is the legal document, to represent or act on another's behalf in private affairs. Now, this may be financial power of attorney. There's also health power of attorney, but for tonight's presentation, we're going to talk about the financial power of attorney. So the POA acts as the loved one. So the POA can transact as the owner. The key to this is that the power of attorney is only valid during a loved one's life. So if my dad has put me on his account as power of attorney, he's had the written document drawn up, typically by an attorney. presented that to his financial institution, stating that I can transact as him as the power of attorney. Now, once my father passes away and I'm power of attorney, I am no longer able to transact on that account. So it ceases when a loved one passes away, but it grants all the same access as a joint owner while that loved one is living. In terms of what is needed, again, that written power of attorney, typically drawn up by an actual attorney. And then that is presented to all the financial institutions, and a new signature card is completed. So you would have the loved one sign as the owner, and then the power of attorney would sign as the POA. Beneficiary, that's the next term that we'll kind of talk a little bit about. The definition of that is a natural person or other legal entity who receives money or other benefits from the benefactor. So in terms of a financial institution, the beneficiary is the person that receives the money in the accounts after the loved one who has passed. That beneficiary is specifically named by the owner or owners of the account. The beneficiary also has no access to those funds until the owner passes away. So a lot of times the beneficiary may not even know that they're beneficiary, but the owner of the account has listed them as such. And you can have multiple beneficiaries. A will. This is a hot topic, but a will, also known as a testament, is a legal document that expresses a person's wishes as to how their property or their estate is to be distributed after their death, and as to which a person, the executor, is to manage the property until its final distribution. So a will is typically drawn up by an attorney. Again, it's stating the person's wishes. So if my husband and I have a will, we want to talk about, who's going to receive the money in our accounts. We want to talk a little bit about who's going to get the house, those type of things. So it's really just a direction for the heirs, many times beneficiaries. The one thing that I want to note on here is that most financial institutions will not accept a will. So if a member or a person brings in a will directly to us here at Metco, we are not able to accept that to be able to distribute the funds. So we will actually then direct you or the people to begin that probate the estate process before we can distribute any of the funds.
Regan, I have a quick question if you have time for that.
Absolutely.
Okay, someone is asking if you've talked about setting up beneficiaries. How do you set up a beneficiary on an account?
Oh yeah, that's a really good question. The best thing to do is to go into the financial institution, or maybe there's multiple, and really just sign a new signature card that would list out the beneficiaries. So for example, if I want to put my son on my account, all I would need to do is swing into Metco, tell them that I want to add a beneficiary to my account. They would then do a new signature card, and on that signature card, we have a special section where it lists out the beneficiaries. So that's where I would put my son's name, and then I would just sign that signature card if I'm the only owner. If there's multiple owners, then both owners would then need to sign the new signature card. For a financial institution, we look at that signature card as the legal direction as to what will happen to the funds. So having that beneficiary on a signature card has a date as to the latest SIG card. Good question. I should ask too, are there any other questions, Becky, that we want to answer yet?
That is the only one I have right now, but I will let you know.
Perfect. Okay, so we talk a little bit about the will, that then mentions the probate. So let's talk about this probate process. It is the judicial process whereby a will is proved in a court of law and accepted as a valid public document that it is the last true, or it is the true last testament of the deceased. So as we're living in Iowa, or I am at least, and that's where I've only lived, I do know that per Iowa law, probate is required. But there is one or two ways actually that you can avoid probate. We'll talk a little bit further about these later, but I did want to touch on the first way to avoid probate is if the estate is valued at less than $50,000 and there's no real property. So that means that, you know, my dad passed away. He has $100 in his checking account and he's renting an apartment, or he's living in an assisted living apartment. He does not have any real property, and the amount of assets are under 50,000. So in this instance, I would need to then obtain what's called a small estate affidavit. And again, we'll get into that later, but that is one way to avoid the probate process. And then the other way to avoid probate is to have beneficiaries listed on any assets that you have. That beneficiary listing or multiple beneficiaries is going to be the first place that financial institutions will look to disperse the funds. If there's beneficiaries, they have to go by that, and that's who will be receiving the funds.
Reagan, I do have a question here. Read this out here. So that means even if you are listed as the executor on someone's will, that doesn't mean you have immediate access to their accounts. Is that true?
That is correct. Yes, that's also a good question. If there is a will, it will then need to go into that probate process and the estate is created. I hope that answers that question.
Yeah, and then I assume even with the other one that you mentioned, small estate affidavit, even if they have less than $50,000 and you're the executor on their will, you still can't access their funds immediately. Is that correct?
Correct.
Okay, I think that's what they're asking too. Perfect, thank you.
Yes, thank you. Okay, so talking about that estate, it is the net worth of a person at any point in time, alive or dead. It is the sum of a person's assets minus all liabilities at that time. So that's the true legal definition of it. But the estate is handled by a person that is appointed the executor. So the executor is appointed in the will. So the executor then is expected to carry out the wishes of the will as defined. They manage all the assets, all the affairs. You know, you're paying any bills, any other expenses that are required after a loved one passes. At that time, if you are named as the executor in the will, you then have to provide what's called a letter of appointment, which is a legal document, and it names you legally as the executor of the estate. This is always best to be handled by an estate attorney. They are great resources because a lot of us, you know, we don't know what to do when a loved one passes. So not only are we grieving, but we are also now tasked with trying to make sure that everything is taken care of. So there's a lot of things and a lot of wheels in motion. So having that estate attorney is a great recommendation. They will tell you exactly what you need. So you receive the letters of appointment. You're the executor. The attorney helps you with gathering the tax ID number, because you will then have to open a new account. So it will be in the name of the estate. So it's considered similar to a business account, but the estate has its own tax ID number. And then everything is consolidated into this account. So if you, let's say, for example, my dad has passed away and he has accounts at 5 different places. He's named me as the executor and I've gotten all my legal paperwork, but now what I have to do is I have to take that letter of appointment document and I have to go to these 5 different financial institutions, have them withdraw the money and the funds, which in terms of the best way to withdraw it is to get a cashier's check made out to the estate. And then you'll take that all into one place wherever you choose to open that estate account. Many times they're opened at your primary financial institution. So for me, I would likely open that account here at Metco, and I would just consolidate everything into the estate account at Metco because that's where everything is. It's easy for me. You do not have to have the estate account at a financial institution that your parent did or your loved one did. So again, a lawyer is always very involved in this process. They will help direct you to where the financial accounts are and what you need to do. Okay, so revocable living trust. This is another term. I just wanted to briefly touch on this one. It is, again, a legal written document that is created during your lifetime that determines how your assets will be handled after you pass away. So this is very similar to creating a will. I would say, I guess my full disclosure on this is, as you're discussing maybe what you want to have happen after you pass, discussing it with an attorney to find out if you need just a will or if you want to move things into a revocable trust. They're going to be the best ones to guide you. But again, this lists the assets that you place within the trust are then transferred into or to the beneficiaries once you pass. So it lists out your beneficiaries. It lists out what's called a successor trustee. They're the ones that will then be managing the trust, very similar to an executor. Revocable, that term is important because it means that you can change your trust at any time. So maybe you write it and unfortunately you had someone pass away that you had listed as a trustee in there. You can change the revocable living trust. And then at the bottom, I did just kind of note that there are irrevocable trusts, which means that they cannot be changed. They're much more detailed, and because you no longer control your properties, there is typically a trustee that is outside of the family that manages that. Again, the best advice is to discuss whether it's the best one is a revocable or irrevocable for you. Okay, I'm going to take just a quick pause and see if there's any questions about terms or definitions.
There is a question about the small estate affidavit.
Okay.
If you get one of those, so going back to that, if the person that you has passed away has less than 50,000 and no actual real estate, how long before I can consider the money mine? So maybe, Regan, I know we've talked about it, explain that 40-day thing, or is that later in your presentation?
It is. It does. I touch on that a little bit more in depth. Maybe what we should do with that question, if the owner of the question doesn't mind, is hold off on that one until I get to
let's do that.
Yeah, part of the next steps will actually go through the different steps upon what, I guess, category you're in or what you need to do.
Perfect. Let's hold off on there, and then person that asked that, if you have additional questions after that, just let me know.
Perfect. Okay, so
Sorry, one more quick one just popped in,
No,
Reagan.
you're
Can
fine.
I'm sorry, I have trouble with that word. Can a beneficiary be a minor?
Yes. The short answer on that is yes. You can name whomever you want as the beneficiary. You can name organizations. Some people will have all their funds donated to United Way, for example. You do have the ability to name that. And then again, that if once you name a beneficiary, it stops there. There's no estate, there's no probate, there's no small estate affidavit, there's nothing else. All those funds will be distributed to the person or entity that is listed as beneficiary. Okay. So the first step, I have these next steps kind of, I guess, split up into following whether it's in an estate or into a small estate. So the very first thing that will need to happen is to obtain the death certificate. Now, a funeral director will many times help with getting that for you. And you should be able to order multiple copies. I say multiple copies because what you'll want to do is you're going to want to keep your original and possibly use that to notify insurance companies, maybe notify financial institutions, but you can also gather certified copies. I know, for example, here at Metco, a lot of times that we'll see the original death certificate and then we make a copy of it, but on it we'll write viewed original. We do that just so that we can verify that we saw the original, but we're not going to take that from our members. You can also get copies or request copies from the Vital Records office. And again, just I would recommend getting multiple. So maybe you know that there's 5 different accounts. Maybe you want to snag 3 copies. But again, that funeral director will definitely help you with that. So that is going to be your first step, no matter what route you need to take. Okay, so we're going to now tackle the situation where a loved one had a will or they had a trust. So if your loved one had a will or a trust, you will need to file that with the probate court. Again, the best advice is to contact an estate attorney to help you with this entire process, because they will tell you exactly what you need to do. The executor will then take over that estate. They'll contact the financial institutions where the loved one had accounts. So if you have multiple, I've heard of many people that have come in and said, I didn't realize that, mom had accounts at every single credit union in town. I had to drive all over just to get this all taken care of. We'll kind of touch on that a little bit later too, but that's the importance of communication. So a lot of times you can find out where accounts are. They might all be listed within the will. They should be listed within the trust at minimum. So once you notify the financial institution that a loved one has passed, the financial institution will freeze the assets. No access is given at that point until the estate account is opened. And then you will also need to contact the Social Security Administration. That will let them know that the Social Security number is no longer active. And then they will work with people that are receiving the Social Security income. What I will tell people in this instance too is the last Social Security deposit that came in, even, let's say that it came in on the 3rd of the month and a loved one passed away 2 weeks later, there is a good possibility that those funds will be taken back by Social Security Administration. So the best advice is to always keep that last full check, or expect that you'll have to pay that back, because they will automatically pull it out of the account that it's deposited into. So the financial institution will freeze the assets until we're given the estate documentation and the estate account is opened. We will also, most financial institutions, if not all of them, will review the obituaries every day. That is just to protect the loved ones in the process and make sure that all the funds, in case they need to be given back to Social Security, are there. That is why we freeze it. And also, if a loved one, someone passes away, we don't want fraud to happen. So we freeze the accounts and make sure that the next appropriate steps are taken. So if assets are listed within a trust, my first piece of advice is to contact the attorney that drew up that trust. But it is at that time that the successor trustee takes over. So same as the estate, funds are frozen unless a trustee is listed and they are still alive. So that's step 2 with a will or a trust. For step 3, for the estate account, this is where the executor starts to take control. I say control, but they really handle all the last affairs of the loved one. So they might be writing checks and paying bills and paying utilities, paying insurance. And then everything is consolidated in together until the estate is ready to be closed and dispersed. Now, one of the things that I will say is that an estate could be settled, within a matter of months, and it might be settled in a matter of years. It really just depends on how complex one's assets are. So I do, again, I'm going to say this a lot just because there's a lot of legal things that go on, but follow the attorney's advice. Many times they're going to ask for statements. They're going to need statements on the date of death. So you'll, as the executor, need to reach out to the financial institution and ask for statements. They need to know balances. And this is going to allow them to completely disperse the estate at the appropriate time. Now, the reason the attorney cannot call is because the executor is the only individual that has access to any accounts anymore. So as an executor, there is quite a bit of work, but it all depends on how things are written, but also how things are kind of settled at the time of death. The last tip that I have on there too is sometimes a will name more than one executor, and it should state within the will whether or not they can act independently or if they must act together. My best advice is to enable executors to act independently from one another. If they have to act together, that means anything that goes out of that account has to have both approvals. So if my dad had passed away and he named my brother and I both co-executors, and there's not a statement that my dad has said you can act independently, one can control it, one doesn't have to do anything, then if I write a check, I have to have 2 signatures to pay Mid-American or pay the nursing home, maybe where I was living. There has to be 2 checks. The other key to that is, I would say the majority of financial institutions will not and cannot open an account that has 2 signatures required to withdraw money. So that statement either must be in the will, or you can go back to the estate attorney and ask them to have that created. I should note too, I kind of just ended that. But when it comes to an estate account, like I said, it can take a couple months. It might take a couple years, especially if there's property involved. It can take a little bit of time because that property has to be sold. But even though I'm just kind of cutting off this slide, I really want to let you know that there's a lot that goes into it, and it can be a moving piece and a lot to do over a period of time. But once you get to the point that everything has been paid, the property has been sold, and it can be dispersed, then the attorney will essentially just cut the checks for anybody listed as beneficiary or who's receiving what property. Okay, so moving on to if someone did not have a will. So the best place to start, or my recommendation, is to determine if accounts had joint owners or beneficiaries. So you would want to start with banks, credit unions, insurance companies, investment companies. If there are joint owners on the account, those joint owners can withdraw and access the funds as they wish. They should change the ownership of that account to their name only. So an example of this is if my dad had passed away, but he put me on his joint owner, then I can just go into the account. I mean, if I wanted to, I could go in the day that he passed away and withdraw all the money. There's no limitations because I'm a true joint owner. Now, if there's no joint owners, but there's a beneficiary listed, the beneficiary will need to provide the death certificate, and then they can withdraw all the funds in the account, or if they're listed as beneficiary in multiple accounts, they can withdraw all the money, no time period. Now, if there's multiple beneficiaries, so let's say that my dad passed, he named my brother and I both beneficiaries, Metco Credit Union would then divide the balance equally. So if he had $100 in his account at the time that he passed, I would receive $50 and my brother would receive $50. And that's if, you know, once we provide the death certificate. I think we had a little glitch in our internet connection. Okay, so sorry to cut you off. I guess cut myself off. But I know that we were talking about freezing accounts, and then dividing up the funds into the beneficiaries. So as long as if there's no joint owners on an account, there's no will, but there are beneficiaries listed, then the financial institution will freeze those funds until the beneficiaries come forward. Now, if there's no joint owners and there's no beneficiaries, the best place to start is to gather a list of assets that you know about for your loved one. Maybe you can find financial statements, maybe you can see tax returns. You know, maybe they had a nice, lovely, organized file cabinet. But what you're going to want to do is you're going to want to take all of those accounts and see if you can combine or get a list together and find out if there's any property. So if they owned any real estate, and where the dollar amount of all the cash is. So if the loved one had no real property or assets exceeding 50,000, then the small estate affidavit is what is next. Okay, so again, no joint owners, no beneficiaries. My dad didn't own any property, and he had, you know, let's just say $100 in his account. The family member, typically any family member, so maybe it's a child, a sibling, grandchild, they are the ones that typically will be the one to complete the small estate affidavit. The key on this is that you have to wait at least 40 days from the date of death to submit a small estate affidavit to a financial institution. What you need is the death certificate and then a general description of the amount of assets. There is a small estate affidavit form. Many times you can find one, I think, online for the appropriate state. And then you might even be able to go into the bank or credit union to ask for their help. They might have a form on file or help find a form for you. They can help answer questions, but they just cannot complete the form for you. At that time, the funds are then dispersed and the account or accounts are closed. Okay, so I know we've kind of covered a lot here. We had some interruptions. I definitely thank you all for bearing with us and our technical issues. So one of my biggest suggestions is that you're going to want to talk to your loved one about their wishes prior to their passing. So this is never a fun conversation to have. You know, you're going to want to ask if they have a will or ask if they have a trust. You want to maybe find out how their accounts are set up. Ask where they want their assets to go. It's just definitely one of those conversations that I think there's a lot of value in it for those of the loved one that passes. There's also value in it for the one that passes because they're able to share their wishes. So if they don't have a will, they don't have a trust, they don't have any intention of completing one, you know, you might even ask the questions, do you have any joint owners on your account, or do you have beneficiaries listed? You know, I just want to make sure that I'm taking care of your wishes after you pass. And then if they don't have any joint owners, they don't have any beneficiaries, you know, maybe discuss the idea of them adding one of those. All right, so just a real quick reference, kind of a summary of the terms and kind of what it means. So a joint owner, you have full access while the loved one is living, and then you have full access after their passing as well. Power of attorney, you're able to help the loved one while they're living and only while they're living. The beneficiary, they are the ones that receive the account balance given in a lump sum after the loved one's passing. An estate is where they own real estate and or they have assets that are over 50,000. Best piece, grab an attorney. Trust, again, that is something that's set up while someone is living. You have multiple accounts, investments, assets over 50,000. Get that attorney as well. And then the small estate affidavit, there's no real estate owned, have smaller balances, no joint owners, no beneficiaries listed. And the key here is that you wait that 40 days after passing to claim the funds. Okay, so we are now at the point with questions. I would love to hear them. If you want to turn you're welcome to turn your mics off and ask the question that way, or you can chat the questions, whatever works for you. Okay, so I think we have some coming in. Okay, so there is a question about contingencies, whether or not they can be added to beneficiaries. I will say that yes, you can have contingencies. However, I would say not typically at financial institutions for your everyday checking savings accounts. You would list your primary beneficiary, or maybe you have multiple. So if I have, let's say I had 2 children, and I name them both, they both get 50-50. Now if I had 3, they each get a third. Now, I do know contingencies can be added to, I believe, life insurance, and I'm not for sure on investments. Okay, so this question is, does a trust avoid probate? Yes, it does, because you're actually going to be fulfilling the loved one's wishes with the trust direction. So again, that's where the trust attorney will come in, and you don't have to go through the full estate, full probate process. And there might even be some additional benefits to a trust. That's just a little outside of my wheelhouse. But a trust attorney would be able to advise you on the difference between a trust and an estate. Had another question about when can you get the money with a small estate? Again, so as long as there's no real property and the assets are under 50,000, you must wait the 40 days and then complete the small estate affidavit with each financial institution if there's multiple, and the money is withdrawn at that point. Any other questions? Okay, I'm gonna take that as a no, but please know that all of you are able to reach out to me one-on-one. I'm happy to answer any questions that you might have, to the best of my ability. I'm not able to answer trust, or excuse me, tax information. Just I'm not, an expertise in that, but I will definitely help you to the best of my ability. Oh, hold on, we just got one more question. Can a joint account signature card be sent out of state? Oh, sent to an out of state person. We can send out signature cards. We don't typically like to do that just because that is the legal document. We don't want them to be, changed in any way. However, there are times that we can mail it either to another financial institution. We have a lot of sister credit unions around nationally that we might be able to send it to, and then have a signature added at that point. We just do require that it is done in front of a notary. Good question. Okay, well, with that, I thank you all again. Thank you for bearing with me with all of the IT things that are just not my favorite things to do. But again, if you have any questions, you want to talk to me one-off, I am more than happy to do that. Definitely ask me anything. And if you think of something later, I am here.